Very good. Well, thanks for hanging out today, everybody. David and I have done several of these. I know many of you have participated, but we've got a ton of new people, it looks like, in today as well. So
Wow.
thanks for joining. I think, as we walk through this, a couple of things. Remember, when you need real legal advice for real situations, you need to make sure you're talking with your legal counsel about that. The other thing certainly is, we're going to try and go for an hour and a half today and answer as many questions as we can. We're going to try and go in kind of a logical order, but we know you all have a ton of questions that you want to think about and talk about today. So we're gonna do our best to do that as we walk through today. And we both have the chat window open so we can really try and monitor any questions that pop up as we go through things. And I think the other thing to start is, welcome to the excitement that's been 2020. I think even
Golly.
on our planning now, we all have lived with the reality of, the guidance already changing multiple times. And my guess is it may not be the last time. So the other, I think, important caveat for us today is we're starting with what we know today. And, different executive orders from the governor, different guidance from ISBE, or other factors certainly can change that as we move forward. But, I know you all are working very hard, and, some of you in new chairs as of yesterday and today, and figuring out how to make these things work. And so we just hope, more than anything else, this is a useful conversation for you all, to be able to have that legal perspective as we think about these issues. There are so many educational, pedagogical, and practical considerations, you're going to have to be working through in your districts. But I think, we want to look at the big picture, some of the legal issues that are there, and get into some of those questions. So David, any thoughts before we jump in with our first question, which is a doozy?
No, let's go ahead and get into the material here.
Very good. Well, a couple of big picture questions that you all have sent, and the first one I think is maybe the key question of the whole conversation, which is, if we don't follow the Department of Public Health and ISBE guidelines, so what? What are the consequences if we don't follow those guidelines?
I,
So David, you want to jump in first on that?
Sure. I mean, if I'm honest, I think that's the most important question. If we set aside everything else, that's probably the most important question we're going to take today for a variety of reasons. I want to point out a couple of things. First, obviously I've had that question a whole bunch in the last several days, as I'm sure have you, Brandon. And one of the early questions that I was having for superintendents who'd asked that question was, what's your insurance company saying? How do they, what's the nature of your policy? Because a lot of these insurance policies have exclusions for transmission of infectious disease. So I asked them, before we even review the policy, I want to hear what the agents are saying. And the first several that got back to me, the lines from the agents weren't, I thought they'd gonna dance around the issue a little bit and sort of pass it back, but would leave some room. The first couple I saw back didn't leave any room at all. It was this blunt: if you don't comply with the guidance, we will not cover you. Now, I'm going to be honest with you. There's some, I mean, I might push back on that a little bit because, of course, intending to comply with the guidance is easy to say. Actually doing it in a lot of these changing environments may be very difficult to actually do,
Right.
at least not perfectly. But I want to point out right out front, there's a big insurance issue here, and they are requiring, and they're going to require, that school districts comply with the best safety practices. And frankly, I'm not a doctor, Brandon, to my knowledge, you're not either. And I know none of our partners are. And nobody working with us is. And the reality here is, I'm sure most superintendents aren't medical doctors as well. We're going to have to listen to doctors if we want our very best defense for purposes of keeping intact that tort immunity shield. And the DPH guidance is Department of Public Health, was crafted by the Department of Public Health as well as ISBE. And whether they've got it right or wrong is certainly up for debate. But whether violating them those guidelines is going to subject us to additional liability, I don't think there's a lot of likely debate around that, because I think the likelihood is very high right now that if there are guidelines that tell us this is what you have to do and we violate them, it's high likelihood that a court's going to find that potentially breaches the tort immunity shield, that it's willful and wanton disregard for safety standards that are published by safety experts. And the problem for us is that gives you two problems. It's not just your general liability carrier, it's also your workers' comp carrier. And it's also just general liability. And we've already seen that case filed. That's not it could happen. It has already happened against Walmart up in the Chicago area, where an employee filed against the school district or the employer, Walmart, saying, even though you did comply with the guidelines, you didn't comply narrowly enough, and that potentially breaches the willful and wanton shield.
Yeah, and I think the key thing you said there as well is, remember, it's not just general liability; it's also workers' comp, which is going to be a huge component of that. And I think leading into the second question, I think makes me think of some issues related to that, because the second question relates to signing waivers. And I think one of the things we recognize is sometimes that lawsuit is brought by people who aren't the direct people involved, right? And so if someone catches it from their student and they pass away, it's going to be the state of that person who never set foot in the school building who might be looking at a claim here in terms of a duty to protect and other things that go on. So I think it is important for us to think about that, as we've seen some cases around Illinois where have gotten some media attention where there were unofficial proms and, kind of an explosion of cases after that and those kinds of things. I think we need to take great care in that regard. But that leads to question number 2, which is, one of my board members has asked about giving parents the option of signing waivers of liability for the wearing of masks while at school. Would such a document hold up in a liability suit?
So I got two things that I think are really important there. First, as well-intentioned as those waivers routinely are, Brandon, I know you've seen them, and so have I, where I've thought to myself, and I've said, look, I'll draft you the waiver, but it's not worth the paper it's written on, because I can't waive the liability, my duty to provide certain things. But there's a second problem here, which is that the liability is not from the person wearing the mask. It's the person not wearing the mask infects. And because the purpose of those masks is not just to protect you, it's not primarily to protect you, it's to protect other people. What I'd need a waiver from is the person who's wearing the mask who gets infected. And of course, the likelihood I'm going to get that waiver from that person when they're wearing the mask is pretty low. Additionally, even if everybody signed the waiver, I'm not sure the waiver is enforceable, because there's a litany of case law that says those waivers are only good to the extent that people aren't willful and wanton in their disregard of safety. And therefore, the waiver may be blown up right out of the gate, because if there's no legal basis for the waiver, particularly conditioning education on that waiver, where we're required to provide that education, whether you sign that waiver or not, I think we're going to have a problem enforcing the waiver in any way, shape, or form.
Yeah, I agree. I mean, I think generally speaking, having kids sign a waiver to attend school is probably problematic legally and constitutionally anyway. But I do think that question has it backwards, because the mask is not about protecting the person wearing the mask. The mask is about protecting other people. It's about preventing the transmission, and that waiver isn't going to do anything to correct that. One other question that popped up here I just want to answer real quick before we jump into some of the bargaining and staff issues next. Question here is, since these guidelines are out now, should we be following it now, or do we wait until August? And I think the answer is emphatically, they are in effect today.
Now, yes.
The executive order is in effect. It is the current state of rules, and that's what must be followed from now until that executive order gets extended. I mean, I think the other sort of big picture issue we've got to recognize is the executive order that gives the legal foundation to these guidelines now, as these go 30 days at a time, is in effect from now until July 26th, then at that point, then presumably there will be another executive order, which may be the same, which may be different for that next 30-day period. So I think absolutely and emphatically the answer is all of these rules are in effect now. We'll see as they continue to evolve.
And
But
Brandon, if I
Sure.
can piggyback on that real quick, I just noticed another question that came in that I think speaks directly to that. That if to the sort of broader picture, if we've got boards of education who are concerned about, because I want to acknowledge the tough job you all have ahead of you right now. Boards, administrators, teachers, you all have a tough job right now because you're sort of getting fire from both sides. You got that fire from the side of folks who might get infected, but you also have a large group of folks who say, I don't want to wear the mask. I'm not going to wear the mask, and that's very frustrating. And I want to acknowledge that you're in a tough spot as superintendent, and of course, we're all there together. And I want to offer this thought that there is a case out of Chicago where that held liability against the superintendent for failing to advise the board appropriately, and that caused the superintendent to lose her job. But I want to point something out, and I think that scares a lot of superintendents, and it probably should. But I want to point something out to you, and that is that all of us at the end of the day serve the board. All of us serve the board. The board is in charge. Our job is to provide good advice and then to defend whatever decision they make because they were elected and we weren't. So two things. One, obviously, we're always going to do what's morally right for kids. End of discussion. That has to be our guiding principle. But the board is elected to make those decisions. And I want to free you all of the liability for decisions that are really not made for you, by you, so long as you're giving good advice. So in terms of protection of everybody here, a lot of these discussions have to happen in open session. That's protective of everyone. Remember, we're going to talk a little bit about the OMA. There's going to be some recording required. It's important that that recording happens. It's important that you're sending emails and documenting, this is what my advice is. This is what I know to be true. I've listened to all the law firms. We're all doing these webinars, and they're really important for everybody to go to. And I'm glad that you're going to a whole bunch of them. Hear as much as you can. Get information from IASA, get information from IASB, distill what you believe the right answer is legally and pedagogically and everything else. Get your right answers, make sure the board gets them. And then once you do, once you've given them the right answers, you're not on the hook for the decisions that are made when you're not the one making them.
Yeah, I think that's absolutely the case. And I think that's where we need to recognize where, we are all doing our best to figure out what the answers are. And as the answers keep changing, we keep adapting. But I do think it's really important for us to, we're all in this together. And I think that, we need to recognize that also some boards are going to make decisions that other boards disagree with that may or may not be compliant. And, at the end of the day, everybody's going to figure that out on their own. But I think legally speaking, one of the big areas that I think is important to emphasize as let's look first at some staff and employee issues, and then we're going to talk about some student specific issues. Sort of the second half of our conversation is really getting into the bargaining implications of some of these rules and guidance and where we go. And I think to lead us into that question, we got a great question. When you look at the statement that was included in the change in the statute for remote learning and blended remote learning, and there was a statement in there about from 101-643 that says this section does not add any new bargaining rights and does not remove any established bargaining rights. And the question we got is, what does that mean? And what is it that we need to bargain now? Do we need to bargain the wearing of masks? So David, I'll let you kick off that question with issues related to the bargaining implications.
Sounds good. So the answer here is yes and no. Yes, you've got to bargain any change to working conditions. And I'd love to see a show of hands of how many people were requiring masks last year before this all started. My suspicion is the answer is a great big donut hole. None of you. And so, yes, when there's a change to working conditions, you have to bargain. But we bargain all kinds of things that are changed to working conditions that we don't have an option on, right? But we have to bargain. Many of you who I see on my list of attendees here, I know were at a lot of my sessions last year with IASA and ISBE and everyone else, where we were talking about minimum wage and we were talking about minimum salary. And you heard me say, you're required to do it. Yes, you have to bargain it. You can't just give this money to the new people because, of course, the people who've been here for a long time are going to say, well, what about me? So you've always put 2% on everybody. I know you got to put 9% on them. You're going to put that on me too, right? And we, sort of had the chuckle about, it's probably not going to work that way, particularly where we don't have all the funding that we need. And so, yeah, we got to bargain it, but it doesn't mean we're going to bargain in the same way we've always bargained. And it doesn't mean that if we don't reach agreement, that we don't have to implement that which the state requires us to implement. That same thing is true in this environment. Look, I want to be clear. Right now, there's no question masks are required for everyone, full stop, setting aside disability requirements. They're required. And for that reason, there's going to be a change to the working conditions for your staff. And so there's at least an impact discussion, if not a decisional discussion. But at the end of the day, I think it's really an impact discussion here, because from a decision-making standpoint, we're requiring masks. How those masks are worn, when they're worn, where they're worn, what the exceptions are with regard to English language learners, for instance, and other such things, that's in removing and putting back on, as well as enforcement, because remember, that staff that you're bargaining with is your first line of defense for purposes of enforcement. So what do they do? And it's a big question I've had. What are you going to require them to do when a student shows up without a mask, or worse, a student shows up with a mask, is wearing the mask when they enter the building, and then they take it off? Those discussions, to some extent, a lot of that is management discussion, but that doesn't mean there's not an impact for the employee, because the employee is the one who's ultimately going to be your first line of defense for purposes of enforcement. There's going to have to be a procedure there for where does it go, who does what and in what order, and how do we comply with the guidance requirements on quarantine and isolation, and on enforcing the rules as they are. So yes, this stuff is mandatory, but even though it's mandatory, that doesn't mean there aren't impacts on your staff. Now is a great time to get started on some of those discussions, because I will tell you that in the couple of places I know of where they've begun starting that discussion, I've been surprised by some of the things I'm hearing that the teachers are concerned about, because in some places they weren't what I thought they'd be concerned about. That's also true for remote learning. It's true for blended learning and hybrid learning. There are impacts for all of that stuff, particularly as the rules have changed the minimum basis and 5 clock hours for what that means.
And I think, leading into that, I think the recognition is, I've seen some people say adopt your procedures and then ask the union if they want to bargain over it. And I think that's the backwards way to do it. I think you need to have the conversation with the union first, then you're going to adopt those procedures we need to think about. And I think that that's for, a lot of different factors you're going to have to look at. It's not just the mask, it's the symptom check process, it's the use of sick leave, it's the use of FMLA, it's how those things are going to interact. And we've got a lot of questions about those that we're going to move into now. The potential disciplinary consequences for not following, all of those things that need to be in place. So I think that is, that's the reality of where we are. I think then the next set of questions that we've received, and I think there are a lot of those, start to go into the different options for staff in different situations. So those staff who are medically unable to work because they've been advised to stay at home, those staff who are, because of exposure or other factors, are required to isolate, and then those staff who are just simply not comfortable returning to work, and what those rights are. And I think it's important, to recognize that all of those categories have slightly different answers, because there are different legal implications that may pop up for them. And so, I think that for that employee who has an underlying medically valid and documented basis for not being able to return, I think they certainly fall within the emergency paid sick leave for at least 2 work weeks, and then likely have the ability to use their existing sick leave beyond that, consistent with the collective bargaining agreement that would play out. I think that that is potentially different when it comes to someone who's just unwilling or uncomfortable returning to work, not for one of the FMLA qualifying reasons or emergency sick leave qualifying reasons, or something that would otherwise permit the use of sick leave potentially. And I think that comes back to a local decision of bargaining and practice in terms of how sick leave days get used and whether their normal sick leave allotment can be used for that purpose, or whether we have remote work that we can and will assign them as well. I think that's something else that's anticipated in the federal legislation as well, is to the extent there is remote work available to them, then we would assign them that. And I think as we're looking at our various plans, and if there is the possibility for that staff member to work remotely, then that's something I think we at a minimum have to consider. But those are still working conditions that would have to be bargained and agreed to with the union in that regard.
Yeah, and ISBE encourages, I think the language they used was strongly encourages, school districts to consider some sort of blended learning arrangement. I think in anticipation of the fact that there will be people during this period that can't work. And therefore, if it's available, meaning if we've agreed to some sort of blended learning arrangement. And again, I can't emphasize enough, you've got to have agreement to that with the union before you try to implement it. Assuming we've got agreement, and one more piece, that agreement really needs to be in writing. I've had a lot of folks say to me, well, my union president didn't object. That's not the same as written agreement. Those are 2 different things, because didn't object doesn't mean they waived their right to complain. And I've already seen some pushback in some places where the union didn't object locally, and then they talked to IEA, and IEA objected. And so now when they came back, the UNICER's telling us, look, she didn't object, but that doesn't mean she waived her right to file a lawsuit. She's got 180 days to do so. So you might get your complaint middle of the year when you've got an employee sitting at home and has decided that they really like this sitting at home thing, and why should they have to sit in front of the computer for 5 hours because the kids aren't listening anyway. And that's a practical reality that's here. Your best defense in that situation is going to be, well, this written agreement requires that we do it. It doesn't have to be in your collective bargaining agreement. Could be a written MOU. Frankly, in some situations, might even be an email exchange back and forth where the union president doesn't just say, I don't have a problem with it, but actually says, yes, I agree. That's what we're going to do. But I think it's important that if we have those plans available, that we understand that at the end of the day, if the teacher can work from home, they may be permitted to work from home. And in fact, that is what the guidance says, that if there's an available opportunity for them to do so, then we encourage school districts to enable them to be able to do so in the event that there's fear motivation. But remember that fear is not one of the protected classes of sick leave.
That's right. And I think that that's clear also in the federal guidance as well. So I think, just again, for those people who are in that we're just not comfortable group, I think the answer is they probably don't have leave outside of their personal leave available to them unless you specifically bargain that for them. Or you create a virtual work option for them, which again is going to have to be accomplished through bargaining.
Yeah.
A question here related, before we get to some very specific staff-related questions, is should we be sending out a survey now to staff asking if they have reasons to believe they're not going to be able to return, and initiate that interactive process so we can begin planning? I don't think that's a bad idea. I think the way I would think about doing that is a couple important points if you're going to do that. One, I think have the expectations of what that's going to look like as you know them today. Because I think the other thing we all know is all of this is a flexible moving target a little bit
Very fluid.
where things could change. But I think that once you have, you know, the basic framework of your plan and the agreement with the union on that, and then you share that with staff, I think it makes sense as soon as you're able to do that, to share that with staff and invite them, whether via the union or directly, if they have concerns that they can individually reach out. I am concerned. I've seen some folks who want to do things like specifically send out questionnaires about, do you have certain health conditions and those things that I think are illegal under the ADA to be asking.
Yes.
I think instead what we need to be saying is, here are going to be the expectations. If there's some reason you believe you're not going to be able to comply with that, then initiate that conversation. And I think that is the key piece for us in terms of, I think, beginning that process with employees now.
Yeah, I'm really supportive of the community buy-in discussion. But my biggest concern, and I'll admit it's my bias, just as a function of what the majority of my work tends to be, your biggest plaintiff, setting aside special ed, Brandon, your biggest plaintiff tends to be your employees, your union. And so starting with buy-in with them, you said it, Brandon, out front, and I just want to put a giant glowing bulb around it. If you put a plan out there, or you put a questionnaire out there that sort of pushes a result, and I've seen a few of those, without union cooperation, you are just begging for a lawsuit from the union. And a lot of the lawsuits that I defend, I'm sure, Brandon, I'm sure it's been your experience as well, a lot of the lawsuits I defend are not lawsuits of the district did something legally wrong. With unions in particular, a lot of them are bad bedside manner. Just, I wish, I can't tell you how many times I've heard a superintendent say to me in the midst of one of those, I wish I'd just asked him first. I talked to him about it, but I didn't really ask, and I wish I'd done that. So take that advice from your colleagues. It's not from me, it's from your colleagues who've been to the well and back. And just think quickly before you send off an email with, this is what we're doing. Check with your union and just say, hey, does this work for you? Is this okay? Because sometimes just that a little additional cooperation sometimes helps empower them. I recognize it's not a one-size-fits-all answer, because I know there are places that doesn't work. But to the extent you can have buy-in, it'll help.
So we've got several questions here about when we're required to exclude employees, staff members. We'll talk about students here in a little bit as we get into our second half, but we've got a few other specific employee-related questions that I want to answer. The first one is, we participated in a webinar in which it was said that if an employee believes to have been exposed or have symptoms, that they receive 14 days of uncharged sick time before they have to use their banked or credited sick time. Is this true? And I think the answer is, I have no idea what that is talking about. I don't think that is true. What I assume that answer was supposed to be is that could lead them to the 2 work weeks, which would be 10 days of the emergency paid sick leave available under the Federal Families First Act. And so the answer to that is, it's not 14 days of uncharged sick time. It would be 10 days. And that does run prior to your normal sick leave allotment if it's for one of the qualifying reasons of the Emergency Paid Sick Leave Act. So I would say the way that was stated is not true, but is close to something that is true, which is looking back at that emergency paid sick leave piece.
And I want to point out that it's also important in that act, because a lot of the questions I've gotten have been, so we're going to apply this. And one of the things that the FFRCA did was to give the employee the choice, which is unusual for a lot of us dealing with FMLA. Usually what we've been dealing with is a lot of, here's how it works. This is what their rights are, and here's how you have to apply them. That's what I'm used to advising. Well, under the FFRCA, the employee has the right to make the choice. They can take dock time if they want for those 10 days ahead of other benefits, or they can take 10 days paid up to the cap. The cap is $550 a day for self, or $220 a day for a family member with a qualifying condition. And that under those guidelines, that up to that cap, they get 10 days that are freebie days. One of the questions I got was, what does that mean? I'm giving all my employees an additional 10 days? No, as a legal matter, they're entitled to those 10 days up to the cap in at 5,500, which means you're giving it to them and it's not charged against their sick leave. It's not deducted from anything. It's not creditable to TRS independently, but those days become creditable to TRS because of the days they're working. They're effectively working those days for purposes of the 170 calculation.
Just an important clarification we got here. Does that require a doctor's note for that federal emergency sick leave? And the answer is, and I hate to say this as the lawyer's would answer, is it depends. Because if you look at the 6 reasons that are possible under that act, some of them do require a doctor's note and some of them would not. For example, one of them is they're experiencing symptoms and is seeking a diagnosis. So in that point, that's before you get the doctor's note. So those are, or they have been subject to a quarantine or isolation order locally. That may or may, that you're probably going to have some documentation of, or been advised by a healthcare provider to self-quarantine. Those are, so some of those, yes, there will be a doctor's note associated with that. And some of those may be qualifying in the meantime before we get there. So let's talk a little bit about employee exclusion. So if the employee doesn't meet the requirements to enter school, for example, they have a temperature over 100.4, do they use sick leave? Do they use personal time? And if they're required then to quarantine for a certain number of days, does that cause them to use their sick leave? And I think the answer is yes. Other than those first 10 days potentially of emergency sick leave, which goes through December 31st at this point, I think the answer there is after that, you're probably looking at their available sick leave time. The related then question I got from that is, what about the implications of those teachers who are in the retirement pipeline, and then that causes them not to make their 170 or 340 sick days for TRS credit? And the answer is that may mean that they're not going to have the service credit. And if we grant days to them beyond the normal allotment for that purpose, then there could be a TRS penalty for granting those additional days in that last 4-year window.
And remember that there's a TRS creditability issue with block grants that are beyond what the employee can use, but also remember that to the extent that it is actually accumulated sick leave, not dock days, accumulated sick leave that is regular ordinary leave for the employee does count as service credit for purposes of their moving forward. Now, obviously, if they're burning up sick time, they're reducing their ability to retire early. And that's why I think that a lot of the sort of turning tangentially to another question that we have here about what happens when we've got an employee who can't come to work and they're burning up sick days, but really they can come to work and they're complaining, and we choose not to challenge it, or 24-5 requiring them to have an examination, which we have to pay for, and they're going to be, you and I both know, clearly the doctor is just going to say, yeah, they've got some condition that prevents them from coming in. I know I've gotten a lot of questions about, well, how do I get that person to work? Because I need them at work. And I think that, now, I may very well be wrong here, but as best as I can do with my crystal ball, I think a lot of these folks, not all of them, but a lot of them are going to be resolved when they realize they're not getting paid. And even if you've got sick leave time, if you're saving that time for retirement and you're about to burn through 170 days in a school year toward retirement, you've just mandated yourself to work an extra year at the end of your career. And I think as employees start to understand that, I do think a lot of those folks who you are concerned don't really have a qualifying condition, don't really have anything other than just, I don't want to come to work. I understand you still have to pay them, but you're also taking away their sick time as you pay them. And I think eventually that's going to catch up with a lot of those employees.
And for those who are required to not work and use those days because of exposure or other requirements to be out, that's just the reality. They may have to use those days.
Yep.
I mean, I think that's the reality. So let me throw out a rapid fire just as a way of some quick reminders here as a question. So the implications, if I got 4 scenarios. 1, a staff member has documented health issues that require them to stay at home. I think that's an employee who has the ability to use sick leave, including the emergency paid sick leave at the front end of that. 2, a staff member comes into contact with a person who has tested positive. Well, that's a person, I think we have to recognize that when we're saying contact here, we mean close contact as defined, which means less than 6 feet distance for 15 minutes or more, unless wearing an N95 mask. So not just any face covering, to exclude otherwise, even if you're wearing a mask, that's considered close contact, and they would have to be excluded for, that period of time, up to 14 days, as that goes forward. I'm wondering if some of the timelines of that get adjusted between now and school starts, because CDC has some testing based requirements where if you get 2 negative tests at least 24 hours apart, then that might expedite your return. But Illinois has not adopted that guidance at this point. Maybe they will. I think then the next area here is, or a staff member who refuses to wear a mask. And I think that person is someone who is subject to progressive discipline, and we can require and must require that.
Yeah, I think straight refusal is I agree. It's subject to progressive discipline. And, I want to point out, I do want to point out that the tenure teacher dismissal process, because for some of these folks, it may be tenure teachers, as well as the non-licensed employee dismissal process. Neither of these are at-will employee arrangements when we're talking about somebody who's been here for a few years. So I want to point out you have to be very careful walking through that process. But absolutely, if they refuse to comply with the rules of the school, they can't comply. They refuse to comply. You've got progressive disciplinary opportunities there, and that means, written warning, due process, dock days. That means progressive discipline, and eventually we may be talking about irremediable misconduct that warrants dismissal of a tenured teacher. So you do have some serious weapons here, which is, again, why I think it's important that as we're working with our unions, we're protecting those particular arrows, because we may need them.
A couple other things here that I think pop up. One, obviously, the other option here outside of using leave is if that employee can work remotely. And I think a lot of districts are exploring ways that for those employees who may have to, isolate for 14 days because of exposure and they're feeling well, that maybe they're assigned some remote learning responsibilities during that time. And so instead of using sick leave, they've got remote learning. Remember, how that works is going to be a mandatory subject of bargaining. A couple other follow-up here that I think is important. As I read the close contact from IDPH, that's 15 consecutive minutes. So if you're within 6 feet of a person for 15 consecutive minutes, then that is what they define as close contact. And then just, I think, to highlight something that David said, where we got a question about that, for that emergency FMLA for childcare, where they get paid 2/3 pay for 10 weeks. Do we have them use their personal vacation time before? And as David mentioned earlier, the typical rule is we can and should require that. However, this statute for that particular purpose says that's up to the employee, not the employer, in terms of using their other paid time before that. A couple other questions that also have popped up here. The staff member who can't wear a mask for medical reasons. The way I've thought about that, David, I think we've talked about this, and I think we're on the same page, is I think that what that is a request for an accommodation under the ADA. And so I think what we are required to do then is engage in the interactive communication process about that requested accommodation of not being able to wear the mask for medical reasons, and how we can, in the least disruptive way, accommodate that. Can they wear them for certain times and then isolate? Can they wear them and at other times use a face shield? And we know all the face shield stuff that I don't want to confuse us about using those interchangeably, but I think that the bottom line is we need to engage it that way. And if we get to the decision that we don't think that that employee can safely be in work, or we can't grant that accommodation, then we would, because it's a health or safety risk to others, then we might, they may be excluded. Otherwise, I think we walk through that just like we would the ADA analysis, which may include requiring medical documentation of that.
And Brandon, I want to highlight something you just said there. In those situations where there's a medical issue, it's not a simple, this is what the accommodation is and that's what you do. For everybody listening, Brandon did a really nice explanation of lots of different options, and it's not an exclusive list. There could be thousands more that potentially are at issue, depending on the nature of the condition, depending on the nature of the person, depending on the nature of whether they're a student or a staff member. ADA applies to both. Depending on whether we're talking about a situation in class or out of class, there may be limitations that are narrow just in this particular situation. All of those things have to be considered. One thing I've seen a lot of school districts doing already that concerns me a bit is developing policies around the idea that the state requires this and federal law requires this, and we're just going to put the two of them together and mandate this solution. And I think that potentially puts you at risk of a charge of complaint under ADA. And more importantly, it may rob you of some opportunities you have to say no. What I prefer, and Brandon, I think that we're on the same page with this because we've talked about it some, but I think it's a really important point. To my mind, this is not a situation where we develop a policy that requires masks. A little bit like I don't want to develop a policy that says tenure is issued after blank or the board awards tenure. It's not my right. The board can't say no to that. It happens as a function of law. Same thing here. At this point, I recognize this could change. I recognize it could change at 1 o'clock this afternoon, or frankly, it might change before we're done at noon, Brandon, or 12.
We're not going to be done at noon.
No,
we're not going to be done at noon. We haven't even started talking about students yet.
I mean, whenever it could change in 15 minutes, I recognize that's the case, that this could change. But I want to be clear that right now, masks are required. And yes, we have to exclude people who won't wear them. And if that's true, I just want to state that's the law. It's the law. We do have to provide notice. That notice needs to go everywhere. If somebody needs an accommodation, they need to come talk to us. And that's what that notice should say. The law is masks. Masks are not optional. We are wearing masks. It should be everywhere. The law says it. The guidance requires it. And remember, ISBE has the power to dock us pay. So it's not an empty threat here. Our insurance company has the ability not to fund us in the event of a claim of liability. It's not an empty threat. We're required to do this. It's not us. Superintendent didn't make that determination. The board didn't make that determination. This was made by the state. Put that everywhere. Door to the building, door to every classroom, door to the bus, window of the bus where it can be seen before they get off the bus, when they get into the cafeteria, when they're leaving the cafeteria. Put that sign everywhere. And that, to my mind, is your notice. This is not about putting it into your handbooks.
And I think just to emphasize a couple other questions that have popped up on that front before we get to our last couple very specific questions on staff issues before we move into student issues, which are, I think the staff member who refuses to wear a mask is not permitted to even enter the building, as would no other human being who is not permitted to enter the building without wearing a face covering, unless we have pre-approved an exception and we are looking for other mechanisms for them to maintain distance and potentially wear a face shield in lieu of as an accommodation in those situations. So I think that's the answer when it comes to employees being required to do so. And I've seen the same question pop up a couple of times, and that is true right now. So if you are having meetings and trainings and all of that right now, the answer is you must. I went in a school yesterday. I wore my mask the whole time, as did everybody else participating in the meeting. It wasn't cool. I felt silly, and I need to just get over that. But that's the reality. I just saw an article published yesterday where a school district, every single one of their building principals is now required to quarantine for 14 days because they had a principals meeting in which they didn't wear masks, they didn't maintain social distance, and somebody turns out was positive. And now there are multiple positives as a result of that principals meeting. What would you do if your administrative team all had to quarantine because you didn't do something as simple as wear a mask and keep social distance during meetings and things? And so we have to really emphasize that going forward right now.
And remember, our insurance companies say our number one duty is to keep everyone safe. So if somebody else is telling us what it takes to keep them safe, we're going to be required by our insurance to keep doing that.
So before we move into student questions and some other things, and we'll come back to some of the questions that also are popping up that are good, but we want to try and get to as many of the topics as we can. Two other quick things. Payment of stipends if sports end up being canceled this fall. How do we handle that, and do we need to bargain over that? We'll see where we're at. I still, part of me believes that there's no way that the state's going to let us not have, athletics, but at the same time, who knows?
Yeah, and be really careful with that. That one really concerns me at this juncture because I am well aware in several districts through experience here is taking the position you can't. Now, the way they're doing that is through bargaining. They're issuing demands to bargain, and in a couple of places, I think they've threatened some broader litigious challenge. But be careful. It's not a matter. Remember that the decision to reduce in force is subject to bargaining, not just the impact. So if you're having that discussion, you need to start with your union, one. And two, I'd be real cautious about issuing any kind of declarative right now because, again, this is a very fluid situation. And remember, there isn't a specific statute that we know of right now, meaning none of the statutes have been directly applied to our coaches. And so there's already some risk because we're past the end of last school year before we made the decisions. So you need to think about those very carefully depending on what your individual situation is with regard to who your coaches are and the likelihood of litigation. But for now, I mean, I'll be honest with you, I've told everybody who can tolerate it, do yourselves a favor and wait on that one, cool a little bit on that one, because we got a month and a half before ISBE believes that schools are starting, whether it's true or not true. We got about a month and a half before they're really feeling under a lot of pressure. And things are very fluid right now. And I'm just very worried that the law is going to change on you, that the guidance is going to change on you, the rules are going to change on you, and you're going to be stuck in a little bit of a quandary and maybe already out the door on a lawsuit before those things change and make it easier for you.
One more question here on that before we move into some of the student related questions. Our union president asked about the possibility of suspending evaluations except for first year teachers next year, given the circumstances we are facing. Have there been any modifications or flexibility to the evaluation requirements?
None yet. We are well aware that there are discussions happening at the legislature. I'm certainly supportive of the idea that when this all changes, it's going to be kind of tough to do some of the evaluation requirements under the law as it presently stands. That student growth stuff is going to be pretty tough next year. I get that. But remember that evaluation is not just our right to evaluate a first-year non-tenured teacher. It is a responsibility. It's a duty. And because it's a duty, again, that can we waive our duties thing, I'm going to advise some caution there. Just we're not going to do evaluations. And remember, I recognize we're in the midst of a teacher shortage, but we may have a first-year non-tenure teacher who's no good, and the law does not say that you can dismiss a first-year non-tenure teacher without cause. The law says you don't have to display that cause in the resolution. You still have to have cause, and you cannot dismiss them for illicit cause. So make sure that in any discussions you're having with the union about how honest you're going to be in your evaluations and how forthright you're going to be this particular year, and frankly, how easygoing you may wish to be, make sure that you're protecting your right carefully to protect the students within your district through that evaluation process. Because again, it's our duty to explain to the teacher what they've got to do to improve, and also our duty to protect the kids. And we don't want to do anything that will suggest that a teacher who does something wrong will be retained, even though they did something wrong that otherwise we might dismiss them for.
Yeah, I think the way we always have to think about evaluation, it's our duty to evaluate, not our right to evaluate. I think that's the way we have to think about it. A couple other key things before we move into our student questions. The question, are masks required if meetings take place and social distancing is maintained? I think right now the answer is yes.
Yes.
Based upon the executive order and the guidance, anything that's happening in a school building, and at this point, I'm going to interpret that to include any building operated by a school, not just, so I'm gonna, probably apply that to offices and other spaces as well at this point, because I think that's the intent for school building pieces when we're in public. I think that's the one. And if you can't accommodate social distancing in meetings, like an IEP meeting where the room isn't big enough, a question I got, I think we can still think about whether some people would participate remotely, because remote participation's always been permitted with parent agreement for that. And maybe we need to look at a different room, if available, where we can have more distance and having that meeting. So, which is a great way to start thinking about some student related issues. And so, David, many of the student related questions we got start with these issues related. I think there are sort of two big areas and then some very specific questions relating to wearing of masks and also the self-screening requirements that are there. And remember, those are also in place for employees as well. So when it comes to, self-screening, I think that ISBE has made clear that it can't just be a one-time, we're good, and I'll let you know if it changes, that it has to be a daily process with those things, that we're going to have to, on a daily basis, have a system for either doing the symptom checks ourselves or have that self-screening be in place, and so I think the key for me, the question was, what will be enough information for parents or students to self-certify that they are free of symptoms? And I think the key is to making sure that you've asked the right questions on the form. I've seen a couple forms already that don't have the complete list of questions that have been suggested by the Department of Public Health, and that I don't think accurately ask the question. So I think as long as you have the right questions, and I think that's what is enough, is a yes or no to that list of questions about symptoms, fever, close contact, and those related items.
And again, impact on the school day. We're going to have that. That's going to slow entrance to school. And remember also that the self-screen happens before they get on any district vehicle too. Before they get here to us, we're going to have to do some screening. That's going to have a big impact on potentially bus monitors, maybe even bus drivers, depending on the nature of your school district. And we need to start to be thinking about those things with our unions and with our employees about how we're going to mandate that. And Brandon and I both have little kids at home. And one of the concerns I have is just, my oldest daughter in particular is one of the more dramatic people I've ever met. She's got her mother and father to thank for that, I'm afraid. And if she's asked, do you have a sore throat? I guarantee her answer is going to be yes at the door. I guarantee it. So we may be having a kindergartner sent home, or a first grader. No, gosh. sent home every day because that's her answer. And so I think we need to think a little bit about our strategies for how we're actually going to begin that discussion. And we need to be sensitive to the different age groups. I'm not suggesting it's not a monumental task or that we're going to get it right the first time we do it, but this is a great place for some collaboration with our neighbors about how are we all going to do this. Being regionally aware here is going to be important, because if, heaven forbid, you get it wrong, if you got it wrong the same way everyone else did, that's going to be a really good defense.
And I want to follow up on a question and something you said. I think that ISBE has given us an unclear answer on the bus piece. I mean, go surprised that we're not getting clear answers, because in one FAQ document, they specifically say before entering a building, in the guidance, they talk about, in the transportation piece in the guidance. And so of the things that are potentially a moving part, I think the transportation piece is one of those that might absolutely be a moving part at this point. I think the spirit of what they are saying is that we would do that before their, that self-certification happens or symptom check happens before they get on a bus, because what good is it if it's not? I mean, is my view. I mean, how is that any different than entering the building? But I recognize the practical reality of that, and also the fact that it says before entering school buildings in their FAQ, and I that's where I think you've got to be working with. If ISBE doesn't clarify it, I think you need a written answer from your local health department and your insurance company on what their expectations on that are going to be.
Yes. And I saw here a question just about the liability. Is there a distinction in the liability of the various parts? And the only thing I'd say right now is, honestly, we don't know about the various options, whether there's distinction in the liability. My caution to you versus self-certification versus temperature checks or other things is make sure that you're asking all the right questions, you're getting all the right answers, all the clear answers, and make sure that when you make a choice of what you're going to do, that it's one of the explicitly allowed choices within the guidance. And I think the best defense we're going to have is, we don't make these decisions ourselves. State did that. And when the state required it, I got to do what the state required. So I don't make a choice as to which one is most or least effective. I saw here, is the electronic form acceptable? Yes, I think an electronic form is acceptable, so long as we can evidence that the electronic form was actually signed.
And we have some privacy factors with that to make sure, if you're using a Google Doc, who has access to those answers, because there's some confidentiality concerns that are inherent with that.
Yeah, PDF and email might be a good solution this time.
Yeah. If we're not able to maintain the 6 feet social distancing and students are wearing masks, are we still able to hold in-person instruction? I think the answer is yes. We have to attempt social distancing to the extent possible or practical. And so I think that is something we think about. Now, the next question is, what about that student or parent that refuses to wear a mask? And I think this is where we have to talk about the difference between, again, the state mandate. I think that's one of the answers is amended in their FAQ, saying we would look at what policies currently would apply and how we would handle that. I think the reality is, again, we're not going to allow somebody to even enter the building if they're not wearing the face covering. And I think that probably also means we're not going to let them even get on the bus if they're not wearing the face covering. And then at that point, they are not at school. And so I think what local districts are going to have to think about in terms of deciding that is, so what is the consequence of that? And I've had conversations with several are thinking about that in different ways. Because again, I think outside of the specific medical accommodation where we've gone through that disability related conversation under 504 for students, potentially with probably with a doctor's note in order to sustain any sort of exclusions to that. And then there's going to have to be separate accommodations that account for the safety risk that student now poses because they're not wearing a mask. Because remember, the mask is not just about protecting that student, but protecting others, and how that student would be able to move and articulate in their school day. But I think in terms of how we handle it, I think that might, depending on, I think, the age of the student, depending upon the reality and the conversation, that can be everything from a reminder to a discipline consequence to an exception. I think that I've talked with some school districts that have said, locally we have such a large number of parents who say we're not going to send our kids to school if they have to wear a mask. And that school district is now looking at having remote learning options available for that group of students. And so I think that's in part going to be, so I think as it stands today, based upon the executive order, there's no wiggle room outside of the medical issue, which would go through a 504 or IEP process to make that exclusion. Otherwise, every student is going to be required to wear a mask. And if they are not, what that exclusion looks like, is it disciplinary or is it we're choosing remote learning in lieu of? And the continuum in between that, I think, is going to be fact dependent.
I want to highlight something from the beginning of what you said, Brandon, too, that we're going to exclude kids who don't wear masks. As a general matter, that's functionally going to be our rule here, because that at this juncture is what State Board is telling us. But I want to note that there's some practical implications here that need to be considered as well. What if we've got a 5-year-old who's not wearing a mask, whose mom and dad are telling him he's not going to wear a mask? I think we've got to have provisions for that, meaning we've got to have masks available we can give the 5-year-old. And my suspicion with a 5 and 6-year-old at home is that when the teacher tells the 5-year-old put the mask on, the 5-year-old's going to comply. And we might get a 3rd or 4th grader who says, I'm not complying. My dad said I don't have to. I'm not going to wear it. Are we sending them home? Yeah, probably. But what if there's nobody at home to take the kid? I think one of the things we need to be thinking about now is, what are we going to do with those kids who we can't bring home? There's nobody to bring them home to. They won't be safe. What if the kid can't comes to the bus stop and he's alone and it's out in the country and it's a walk home and he's 5 years old? He can't go home. We have to prepare our staff with appropriate alternate provisions, masks. We also need to prepare our staff with directions to what's going to happen and our spaces for what's going to happen. Because remember, ISBE guidance now says that we need to have a separate space for those kids to effectively isolate within the building. And that time has to be supervised. They cannot ever be left alone within that room. So we need to think about how we're going to allow social distancing in that space and what space that's going to be and how many kids we're going to have. And that's going to be very different in different communities. And it's going to be different in different buildings. And so you need to think about that locally about how you're going to do that.
So several questions here about the litigation we've seen filed. I've seen that, aware of that. And I mean, here's my answer on that. I think at the end of the day, that's just going to be a blip on the radar that we all saw on Twitter, and its impact will be about that big when this is all said and done. I mean, this is going to be a statewide issue where there's a statewide answer.
I agree completely that the answers here right now are coming from the state. And I want to be clear, there's some help for you there. I recognize that puts you all in a very uncomfortable and unusual situation. I'm as big a proponent as there is about local control of the school district. But this is a pandemic that none of us have ever dealt with before, and we are very much not medical experts. And Brandon and I talked last night after seeing some of these things filed about some of the conversations we were having back in early March that seem a million years ago, where we had a number of superintendents who said, I just wish the state would close it down because it's clearly heading that direction. There was an ISBE website with the number of students who were out of school, 30 school districts at one point. Then it all closed before the state closed. At first, it just looked like, it's a couple of collar counties in Chicago. This isn't going to affect downstate. And then all of a sudden, we started seeing downstate schools closing. There's some good news here. And the good news, although State Board's guidance keeps changing and it's a fluid situation, everything's moving very fast, At the end of the day, it's unlikely that any individual case will by itself change what we are all doing, because each of those cases is going to afflict only the litigants in that case in the short term. In the long term, it may have political implications, and that's what I think you want to watch. I think you want to watch what the state board's doing. I think you want to watch what the governor's doing. These cases are a little bit of a distraction, because although they may have effects, those effects are as much political as they are legal. And so one thing that I'd caution school districts is, to the extent your community will allow you to be patient a little bit. Get planning, presume all this stuff is required, and then get patient about the finer details, because that stuff's changing. And we've already seen, Brandon, have we seen now 3 or 4 additional guidance documents since the beginning of last week that have changed
this
rules, and not
FAQ,
slightly.
since that came out, this is already the 4th version of the FAQ from ISBE. Yeah. I mean, that's...
it's moving really fast, and it's changing dramatically. These are not minor changes. How many school districts purchase face shields, and then the state guidance said, no, you can't do face shields. I mean, it's a tough time for all of us in education.
Yeah, and honestly, what the lesson I've learned from going to this well more than once already this spring is, when ISBE put out their guidance last week, I was like, that's important. We all have to read it. But I'm not going to make any decisions until I've seen the 3rd or 4th version of it, because inevitably we're going to get 3 or 4 versions of it before it kind of settles. And I don't know if we're there yet or not. So I think that's important. So several questions coming in on the same topic that I want to make clear. The guidance and the executive order says those face masks are required in buildings. Outdoors, they're not required so long as social distancing is maintained. So I'm getting questions about things like athletics and being outside and those kinds of things. I think it's clear that anytime you're indoors, regardless of whether or not social distancing is maintained, the mask must be worn. Outside, the mask must be worn only if social distancing of 6 feet or more can't be maintained.
And remember that for purposes of the order, space means any place where there are 50 people who can social distance. Remember that when we're talking outdoors, that 50 people means any group of 50 that is spaced from any other group by 30 feet or more.
And so the question I get, so what I'm hearing is this includes maintenance staff who are in their office by themselves, board members at board meetings, parents and IEP meetings. And my answer is, the executive order says yes, all of those people have to be wearing face coverings.
And socially distanced to the extent practicable.
Yes. So a few more student-related questions here. For those students who are doing remote learning, do we require a doctor's note for that? I would say, if we're limiting that to situations where a student is homebound and we're not going to make a regular and routine remote learning option available, then I think the answer is yes, that requires a physician certification. But I've seen some districts who are having sort of just a voluntary remote learning option for families. And to that extent, I think you could do that without requiring the medical note if you're just having that option in that regard. So I think that is what's clear.
Yep, and remember the non-discrimination rules here too. It is trying to make sure that we're providing equitable arrangements for all students. And remember that you can't always spot the protected class group that we're applying any exclusion to.
The other piece that I think is out there, when we start to get to some of the student-specific questions, and certainly there's the reality. I mean, when we get to some of the special ed considerations, for example, if a student's not using a mask, is there a denial of FAPE if we look at remote instruction? And again, I think that comes back to, that's an IEP team decision, and we have to look at LRE. And certainly I think all of those things affect least restrictive environment. When we're looking at remote learning, Remember, we've got to make sure that for those students, if we're doing blended remote learning and that looks different than their current IEP, we need a remote learning plan for them as part of their IEP. And if that's different than your remote learning plan from last year, then that means updating the remote learning plan through an IDEA sanctioned process before this year to make sure that we are providing FAPE in that regard and for those issues. So I think those are some of again, a ton of questions about special ed. And that's why I'm going to tell you, my special ed folks, I'm going to put together, I'm going to set up here in the next week or so, we can just spend an hour just on special ed issues. Cause we're past our time already today and we haven't touched on that. So I think those are the things we're supposed to do. The other area I want to mention quickly, and then David, I'll let you scroll through the questions to see if there's some things you want to make sure that we're addressing or talking about.
Sure.
We've got some questions about Open Meetings Act and Open Meetings Act related questions, and just please make sure that you are aware that when the governor signed Public Act 101-640, that superseded the prior executive order on Open Meetings Act. And so to have a virtual or remote meeting, or to have a meeting where you don't have a quorum physically present, is now permitted during a declared emergency, which at this point is still declared through July 26th. Mm-hmm. And again, I presume will be beyond that. But there are some specific Open Meetings Act requirements that are in that law that are beyond what we had to do during the spring when we just had guidance from the Attorney General's office. And a couple of those things that make clear is that you have to have at least one member of the public body, or an administrator or lawyer for that body physically present at the meeting location. So if any of you want me to be that person, I'm happy for you to have me come sit and be that person some evening. But a couple other pieces that are really important, which is when you have that remote or virtual meeting, all votes must be roll call votes. So make sure that we can't do a voice vote. Everything must be a roll call for all votes during those meetings. And the other piece that's really, really important, something that David mentioned in passing earlier, is there's a requirement now that there is a verbatim recording of the entire meeting, not just the closed meeting. So when we are doing that, we have to ensure that we are keeping a verbatim recording that would then be available to the public of that meeting that's virtual. And so I think those are the two key pieces that I think were different from most of our practice earlier this spring. And from June 12th on, those two things have been in place that say, one, roll call vote, and two, there has to be a verbatim record of the entire meeting for those Open Meetings Act requirements. So, I mean, here's the question I'm getting in lots of different forms. Basically this: if I walk into the school building, I am not meeting with anyone, I go to my office and I'm never within 6 feet of anyone, should we or should we not wear a face covering? And I think the answer is yes, you are wearing a face covering. Now, if you're in your office with your door closed and nobody else is there and nobody knows, when a tree falls in the woods, does it make a sound? Yeah. I don't know. I was wearing my mask. I don't know what you're talking about during that time.
Yeah, I mean, what ISBE has said in their earlier webinar is, yes, everybody's required to do it. No, it's not optional. And the reason for that is you never know when somebody else might be there. You never know when somebody else comes. Be alert to the fact that when we're looking for a particular answer, it may fly in the face of the facts. So be alert to what the guidance actually requires.
I mean, here's the reality of that situation. If I'm in my office with the door closed, breathing for an hour, that space now might be filled with, and I'm unknowingly asymptomatic COVID positive. That space is now filled with my, particles. And if somebody walks in, they've now been exposed to what might be in the air in that closed office. And that's why ventilation and other things, we've got to think about all those practicalities there.
Brandon, you've got several questions here about the Open Meetings Act with regard to recording if everybody's present, or recording if one board member is out.
I think that this applies in situations where we are holding meetings under the emergency provision, where we don't have a quorum physically present, and we've determined that having a virtual or online meeting for that purpose with remote participation by a quorum or greater is required. So if you're back to your old normal board meeting routine, and everybody's socially distanced and wearing masks, and your total crowd doesn't exceed 50 people, then I don't think those things apply, because your meeting is not operating under that emergency exception. But if you are operating under that emergency exception, then all those rules apply.
And I think I'll add that I think that conceivably, although it's not exactly the way it's written, conceivably that rule also applies where you've got a school district that has everybody present for the board, but is anticipating a fairly large crowd of the public and has basically the boardroom shut down to 5 people in addition to the board, and then has a remote meeting in addition, so that the public can participate remotely. I'd caution there that I think that as a matter of safety, you'll be better off making sure that you've actually got that recording going, and you're doing those things by roll call votes, etc.
Great question here. Yes, I think that what I would make the assumption that the closed meeting verbatim recording rule still stands in terms of public availability. That doesn't change. And I think to make that easier, I would probably make sure that you're using a separate recording.
2 different recordings.
So you can different, 2 different, so that you're not having your open and closed on the same recording that you may have to go back and edit later, but keeping those separate. Question, which executive order am I referring to? I'm referring to Executive Order 2020-44, which says that during phase 4, to ensure the safety of students, staff, and visitors, that we must, including but not limited to, number 4, require the use of appropriate personal protective equipment, including the use of face coverings by students, staff, and visitors who are over the age of 2 and able to medically tolerate face coverings. So that's the executive order that I'm referring to that gives authority to the guidance from ISBE and IDPH.
And I'd offer, be alert to the fact that each one of these orders is a little bit different. They keep changing on us a little bit. So be alert to the fact there could be changes in the future. But right now, ISBE guidance is applicable now. The executive order is applicable now. And that also means that ISBE guidance at this juncture, as near as we know, is going to be applicable all year next year as well. Other questions we haven't hit, Brandon?
Yeah, I think a couple things here. I'm scrolling back through because I know there are several. I mean, there are a lot of things that we've covered as I go through. Maybe not exactly as asked, but in various forms. So I'm going through, a few of these things. Do we have to provide a virtual remote learning for parents who wish to keep their students home? I think the answer is outside of a homebound certification, not necessarily. But I think a lot of districts are looking at that as a viable option because as they've been talking to their communities, they've got a number of staff and a number of students who fall in that category, and that they're choosing to do so. And I think that makes a lot of sense as to why we might do that.
Brandon, I've got one here that I thought
Sure.
was interesting. If you're down that one, since masks are required, are we required to clean those masks daily, or is that the responsibility of the family? I mean, I'll go first on that one. I don't see, unless you saw something, Brandon, I don't see anything at all in the guidance that requires us to bear the burden of responsibility for cleaning those masks. And I'll caution that if we're going to take on that responsibility, that 1, we have to make sure we do it and we're compliant with that, but 2, that we make sure that we're bargaining that because somebody's going to be responsible for that. And that's not as straightforward as it sounds, because of course that person is necessarily potentially handling masks that may or may not be compliant. And again, I'd point out there's a big difference between sanitizing our stuff and sanitizing their stuff. And so
Right.
I think I mean, personally, I'd be a lot, uh, I'd be a lot more concerned about us bearing that burden of responsibility.
Here's an interesting one on the medical exemptions. What if a quack, I mean, doctor starts handing out masks, letters to anyone? What's our ability to determine if they're really necessary or not? I think we always have the ability to make that decision. Our obligation is to consider that. And then I think we have the authority to make that decision in that regard. I agree. Once cold and flu season hits, all of this symptom stuff is going to get really complicated. And
Yes.
I'm wondering, the CDC's, like I mentioned, the CDC guidance on that is slightly different from the IDPH guidance because they account for a testing route to be able to return for exclusion. And I anticipate maybe that might be an option, as so long as tests remain routinely available. That could be something that's there. I don't know that we have the authority to mandate a test at this point for anyone. We
Okay.
would just be able to mandate exclusion. But I do think that testing piece is not in a lot of this ISBE guidance and is a possibility that could, I think, be helpful in some of those answers.
And I want to be careful on the testing piece too, to highlight the thing Brandon said just a couple of minutes ago. Our obligation is to consider, not always to follow. So be alert to the fact that CDC is telling us that there are an awful lot of bogus tests out there that are still out there. So we do need to actually look at what's coming in on a case by, I know you guys don't want to hear this, but it's the truth, that we've got to look at it on a case by case basis and say, what is really going on in this situation? But right now, the guidance is 72 and 10, 72 hours or 10 days from from the cessation of symptoms, and 10 days from the first symptom at minimum. So please be aware that those are still the guidance that we're under.
So our district's required to furnish masks for every student. The executive order says we must provide face coverings to all employees, and to the extent possible, make disposable face coverings available for all students. And the state's going to make certain things available to us. But I do think it's something we probably need to be prepared for. If somebody shows up without the mask, we probably need to have one for them. I mean, and then of course, I think when we have that, they're either disposable, which they're saying make disposable face coverings available, which wouldn't have a cleaning requirement.
Right.
I think if we're giving them ones that have to be cleaned, we're taking on the responsibility to be cleaning and disinfecting, and we may or may not want to take on that possibility. Kind of reminds me of the other day, my daughter had one too many accidents at school as to the number of backup pairs of underwear she had. And then she came home in school underwear. And I was like, I feel the same way about the school mask, I think.
We'll be procuring them in bulk.
Yes.
That's what happens when you get two attorneys on the line. We start coming up with ridiculous solutions because we can give you guys all the good answers here as to what you ought to do. But at the end of the day, we're going to be way more ridiculously cautious. We're going to be the nightmare parents.
So, hey, we're getting close on an hour and a half here. And so I think two things that are there. Again, I think going back to the executive order, it says schools must follow this guidance during phase 4. So I think this applies to all times during phase 4. I think the introduction to that section talks about the summer school and some of those other programs, but I think that the language here clearly states that we have to follow this guidance during all of phase 4 at this point, subject to any change in the executive order. Hey, two COVID or return to school related things that I do think are things we want to be thinking about. Remember, all the Title IX changes you've got to be doing for your handbook and
this year.
policies. And no press is coming, but be ready to think about Title IX over the next 6 weeks. And if you take a look at our Twitter account, there was a really interesting Third Circuit Court of Appeals social media Snapchat case this decided this week. I don't know that it's binding in the Seventh Circuit, but by golly, I think the Supreme Court's going to get to give us an answer on some social media and student stuff, because it's mind-blowing. The court created a whole new standard that no court's ever used before and teed it up very nicely for the Supreme Court. So I think there's going to be a clear Title IX connection, I think, to that Mahoney case out of the Third Circuit. So take a look at that as well.
Yeah, and I'd point out on that case, I think that policy and the way it was applied gave the court very good reason to find another way to get to what would have been the same result under a First Amendment analysis. But the law they sort of created sort of on the fly is both stunning from a school attorney standpoint. I've actually been watching the national school attorneys Twitter just absolutely explode on that, and it's been very interesting. And secondly, it reminds me a little bit of the cases in Illinois or in the Seventh Circuit, TK and MK, Mahaffrey, and some of those others, where they've really sort of assumed the applicability of the Tinker to off-campus speech, and then have found another way to get there. So this court kind of did the exact reverse of that. So that'll be really interesting if it does go to the Supreme Court. I'll really look forward to that decision.
So, hey, special ed folks, I know I skipped a ton of your questions, and I did it for time purposes. So I absolutely am going to schedule one of these for us just to think about special ed issues. I'm going to try and set that up for next week. But next week's going to be pretty tight. So we'll get that as soon as we can. Be on the lookout for that. So look at that on my Twitter account, but I'll email out to my cooperatives as well when that's out there. So be looking for the special ed piece, because I know you all have a lot of questions too. So we'll find a time to be able to do that. So again, thank you guys for hanging out with us today. This is such a time for us all. You know, I think, as David said yesterday, when we were talking, none of us have had to answer these questions before, and there's not a precedent for us to rely on. And so we're all doing our best. We know things are going to change. And so I think what we need to do is have plan A, have plan B, maybe have plan C, and be ready to move. I know you all have done a great job of that. We appreciate working with so many of you guys. It's been so cool and so inspirational on a daily basis to see the hard work that's going on. And, we're gonna get there.
Thank you very much, guys. Really appreciate everybody being here and all the questions. And frankly, your questions really do help us get better at our jobs. That this isn't, part of the benefit, Brandon, for me, when we do these, is not just a function of being able to give some information to you guys, but also to get some information back from you about what's happening in your community. So we really appreciate you joining us and all your feedback. Thanks again.
Thanks, everybody. Happy 4th of July. Happy 4th of July. Have a good holiday weekend. And we'll talk to you all soon.
Thank you all. See ya.